Good morning, everybody. Hopefully everyone's had a great weekend. A little extra day for a new holiday that we had. So hopefully you guys were able to have some nice time with your family or whatever your plans were. If you were outside, I'm sure it was a little bit chilly, at least early in the morning, a little colder than what we would expect for June here. So anyway, we're going to go ahead and jump in and get started as other people are filling in. So as we talked about last week, actually, sorry, I guess it was 2 weeks ago because the summit was last week. We broke it apart where we broke the REPC up in two parts. And so this time I want to tackle the back end of the REPC. Might be a little bit shorter today than normal, but we're going to jump into a couple of things that are most people are unaware of, and so hopefully we'll answer any questions that you may or may not have or may not have thought about. I believe we talked a little bit about we may have actually covered most of section 8 of the REPC, but I do want to dive in real quick with it. And hold on, let me start sharing the screen so everybody can see it. Okay, hopefully everybody can see the REPC in front of them. If somebody can, are you seeing paragraph 8? Somebody give me a voice of a yes.
Yes.
Okay,
Yes.
perfect. Thanks, Jeanette. Okay, so we'll jump right in here under the section 8.1. So the first understanding of what's brought forth is under section 1, where it says, if you were to cancel the REPC based on the due diligence, it makes it very clear. If buyer determines in buyer's sole discretion that the results of the due diligence are unacceptable, then no later than that due diligence deadline, they can cancel the REPC by providing written notice to the seller. So based on that section of the contract, all they need to do is provide written notice to a seller. Now, written notice could be, that could be either a text message, it could be an email, it could be, I guess you could write on a napkin, whatever you wanted to do to provide written notice, and you would fulfill that requirement according to the contract. So my question is that all that we need to do?
I would say no.
Okay, Jeanette says no. Anybody else, whether they would agree or not? Or disagree? And if so, what would be the reason for that? Okay, well, I'll take the silence as this is such an obvious question and not even wanting to waste the time. So the Jeanette would be correct where she would say no. And the reason for this, under this section, providing a text message would work. But the problem that people forget is when it comes down to section 18 of the contract. And so there's another element of the contract that is required. It says acceptance provided in section 23, which we'll read in a second, which is talking about acceptance. All notices required under the REPC must be A, in writing, so that satisfied section B. 8.1. B, signed by the buyer or seller giving the notice, and C, received by the buyer or seller of the respective agent or brokerage who they're representing. So that in writing piece of providing the cancellation, yes, that meets section 8.1 for that requirement, but the contract has two other pieces that are necessary in order to have an effective notice given. So it's A, in writing, B, it must be signed. So a text message is not going to be signed with that text message, or the email is not necessarily signed. So that's one of the main reasons why with our staff, when we're asking for certain things, if you send over a cancellation, we've often come back and said, hey, you've got to provide a notice of cancellation that you not only the notice, but you provide a confirmation or delivery that it was done. So because we've got to provide proof that we've sent that cancellation before the deadline. And whenever we do not meet that standard, then that's when we may ask, okay, in that case, for us to release earnest money, we have to have a earnest money dispute resolution form signed by both parties agreeing for that earnest money to be delivered. So again, it's important that we know what we're talking about in the contract and what section, so that we meet all the criteria. Now, some people have said, well, if I withdraw an offer, does that need to be signed by a party giving that withdrawal? Do I need to meet those 3 steps that are in section 19? Well, technically, if that offer has not ever been accepted, you're not under contract according to the REPC. So the answer to that would be no. But if you are under contract and you're now going to withdraw an offer, then the argument could be a different state that you actually would have to have that written notice.
Rob,
Yes.
if you were under contract, then it would be a cancellation. It really wouldn't be a withdrawal, because
Yeah, but you could have an addendum. Let's say that you wrote an addendum and you were asking for 1 or 2 terms, and then you decide to withdraw that addendum.
Oh, okay.
So that withdrawal form is it's a withdrawal of an offer, counter offer, or even just I mean, the counter offer is it. So it still could apply, but otherwise, yes, you are correct. So hopefully that part's clear. I think we covered this 8.2 section pretty clear, but the main reason why I wanted to bring this up specifically is in conjunction with 8.3. I still get a very common question to me, and that is, if in 8.3, they put some money here in this blank section, that if they're canceling based on that, they can't cancel based on the appraisal and get their earnest money back. And the answer to that question is no. I think the biggest misunderstanding about this section is, even though everything's under section 8, 8.1, 8.2, 8.3, those are each 3 separate conditions that buyer and seller have agreed to make this contract contingent upon. So 8.1 is the due diligence, 8.2 is financing, and 8.2 is appraisal, 8.3 is financing. So yes, those are 3 separate contingencies. And even though the finance and appraisal deadline is often the exact same deadline because we have them written, that doesn't mean that you cannot separate those dates. That also doesn't mean that those are still the same deadline that are applied. You can cancel those dates, you can separate those dates, and they are 2 separate contingencies that apply to the contract. So in this situation specifically, if you are canceling the contract based on the appraisal, and we've gone over this, the way to know for sure that you're truly canceling based on the appraisal versus on financing is you must include with your cancellation a copy of the notice of appraised value. That is what indicates that you are canceling based on the appraisal versus financing. Otherwise, if you don't include that, it will be based on financing. So then it goes back to this section of the contract in 8.3 BI, that whatever term was in this section, if you had $3,000, for example, in this section, and you intended to cancel off of the appraisal, but you didn't send a copy of the notice of appraised value, then you would be canceling based on the financing, and that $3,000 would then be owed to the seller. So that's what this section is talking about, based on the amount of earnest money that will be owed to the seller. So I know we've talked about this. Any questions?
I just have one question. So you only have to send that section of the appraisal that has the appraised value. You don't have to send the whole appraisal.
You don't. You only just that page that gives the value of it, something that indicates the property address, and then something that indicates the entire price. So no, you do not need to send the full appraisal. If you did send the full appraisal, then that obviously would work too. Good question. Any other questions about this? Okay. All right. Let's go down to section 10. So again, these are things that we see often and when other agents draft this stuff, I don't expect you guys to send every offer back to the other agent when they include minor stuff. For example, for whatever reason, agents feel like they still need to write an addendum that says home is being purchased in as is condition. Let's say that they're not making the offer contingent upon due diligence. So they're waiving section 8.1, and then they also reiterate the home is being sold in as is condition. Okay, well, as a reminder, the contract already says that. In section 10.2a, buyer is purchasing the property in as is condition. It already says it. Now, of course, if the agent or you were to write that again, now you're just reiterating what the contract already states. So it should be extremely obvious to both parties that it's an as is condition. But I do want to, since this last couple of years we've been dealing with this, when agents do, or the client does waive their due diligence, other than this first option A, when they waive due diligence, they're also in essence kind of waiving their protection that it would exist under B, the rest of 10.2. Buyers shall have during their due diligence in reference 8.1 an opportunity to completely inspect and evaluate conditions of the property. Okay, well, if they're waiving that due diligence, they don't have that as an option. If based on their due diligence, buyer elects to proceed with the purchase of the product, buyers relying wholly on their own judgment. Now that part would still be the same factor, but they didn't have any contractors or inspectors that went out there. So again, it's based on their own their own opinion of the property, and hence this is the reason why we had that. We created that company form, the waiver of the non-refundable earnest money or waiver of contingency waiver, because these are big issues. The buyer is doing whatever they can to go under contract, and then all of a sudden they close on the property, and there tends to be an issue immediately with the home, and the buyer is going to blame the seller, they're going to blame you, they're going to blame us, they're going to blame everybody but themselves. So again, we need to be prepared for this. Section 10.3, so specifically with the seller, as a reminder, these are the things that the seller is obligated to do. That in reference to the physical condition of the property, the seller shall disclose in writing any material defect about the property. They are obligated to do that. And this is one of the things where, oh, seller's disclosures will not be provided. Okay, well, that doesn't give them a pass to still disclose any material problem with the property. They're still obligated that they've got to disclose what they know about the property. And that's a very big misunderstanding about that obligation. And so make sure that if you do get in the process of waiving disclosures or whatever it would be, make sure you still reiterate from the other side that, hey, even though they're not providing these, they're still obligated to disclose this information. And if they don't, they could be liable. And then, of course, it goes into what they're obligated to do. It says here where it says that they are going to provide these disclosures. Many times, whether it be an investor or a family member who is now inherited the property, they rely upon an addendum that we used to have years ago that said it was a non-occupant disclosure. Well, because the owner of the property has never occupied the property, they relied upon that form to escape the obligation of disclosure. And a lot of these investors that were going in and flipping these houses and doing some renovations, heck, they probably had more knowledge about the house than the actual homeowner who lived in it for 30, 40 years, because they tore everything out and did some replacement. So if the seller and buyer do not agree to waive these terms up front, seller's bound to do it. And you could argue if they choose to not fill out these seller disclosures after they've been accepted, they'd be in default of the contract. So don't feel like the buyer is bound by whatever the seller chooses at that point, if this is not taken care of up front.
So I have a question about that. So
Yeah.
if you get an addendum and it says seller's disclosures not to be provided, the buyer agrees to that, and then you close, and then there's a major problem with the house because the buyer agreed that no disclosures would be provided. Are they still protected that the seller didn't disclose a major defect with the home?
So
How do you, like, as a buyer's agent, how do you deal with them saying, okay, we're not going to provide seller's disclosures? Do we have to do an addendum in writing saying if there are any material defects discovered after closing, or I don't know?
yeah, that's a great question. And of course, the default answer that I'll always give is, if there's any questions specifically that our clients have about this, they certainly should seek counsel with an attorney to get legal advice. But what I think what a fair statement would be, Jeanette, is if they're going to say no seller's disclosures are going to be provided by the seller, you could certainly say, okay, no seller's disclosures will be provided. However, the seller is still obligated to provide any seller known material, anything that materially affects the property the seller has knowledge of. They're still obligated to disclose that information. And they may say, we don't want to do that. And if they're like, we don't want to do that, that's, first off, that's a pretty good red flag for a buyer to say, well, wait a minute, why don't you want to disclose something that you have knowledge about? Well, we don't. It's not that we have knowledge. We're not trying to disclose. We just don't want to be bound by anything. Well, okay, I get it. If you don't have knowledge about something, you're not bound. But if you do have knowledge about something, you would be. So why are you not okay with that addendum? Now, like you said, some sellers may not want to sign that. And if the buyer agrees to accept that part of the contract, then I think it might be harder for the buyer. I mean, it might be harder for the buyer to prove it, to come back and say, well, the seller had knowledge about this leak on the roof and the pipe, and they chose to not disclose it to us. And then you've got an addendum that agreeing that the buyer is going to still accept the contract. I think it might be more difficult to prove, but it shouldn't negate the seller from their requirement to disclose that. Does that make sense?
Yes, thank you.
At least at that point, we're shifting it to the buyer. And as long as we cover our butts and just have the conversation, hey, you need to talk to an attorney for one, but if you're going to put this language and still move forward, you might be hurting your chances of your own protection. I don't know. I'm not an attorney. You need to get that answered from an attorney. Okay, good question. Okay, I just wanted to highlight under the leases. Of course, we know any changes during the transaction. Once we go under contract, the seller is not able to do anything to the property, making alterations. They can't tie up the property anymore by going out and getting a new loan on the property. They can't sign any property management agreements or any long-term leases. But the short-term lease is a little bit different. Short-term rentals, they have up until the seller disclosure deadline, which is different than after acceptance. So if the property is made available in short-term rental bookings as defined in section 6.1, seller may not, after the seller disclosure deadline, continue to accept short-term rental bookings. So that's the big difference versus if you go up here, the seller agrees except in this paragraph from the date of acceptance until the date of closing following the following conditions. So, if seller disclosure deadlines are 2, 3, 4 days after acceptance, that seller still does have 1 or 2 more days to be able to allow short-term bookings. And but then, of course, they've got to make the buyer known. They have to provide any of those short-term bookings by the seller disclosure deadline. That's the reason why this is available, is they have to provide all of that information by the seller disclosure deadline. What liens, what's on the property, everything that's in section 7, which short-term and long-term leases are provided, including any property management agreement that would be addressed here. So make sure you understand that and understand the difference there on the short term. Okay, default. This is still a common question that people bring to me, and I try to simplify it. That the default remedy for the buyer or seller is the same. So if the buyer's in default, the seller has 3 remedies. If the seller's in default, the buyer has the same 3 remedies. But the only thing that's a little bit different, if the buyer is in default, option A, the seller can cancel the REPC, so they can provide a seller's notice of cancellation. And if they choose option A, which is the earnest money, they can retain the earnest money that's being held, and then the deal is done. If the seller's in default, then the buyer, this is the only part that ends up being a little bit different. The buyer can then cancel the contract. They can get their earnest money back that they provided, and then the seller would be obligated to match the earnest money. So that's what this one's talking about. Cancel the REPC. So buyer may cancel the REPC, and in addition to return of the earnest money deposit that the buyer gave, buyer may elect to accept from seller as liquidated damages a sum equal to the earnest money. So many people refer to this as though they get double their earnest money back. Well, it's not double their earnest money. I mean, they're getting their original earnest money back, and then the seller is matching the earnest money. So it's still the same issue, the same 3 remedies, and but it's good to understand the difference. Now, one thing that that also be mindful of, a lot that is very common right now, is when, if you represent a seller, and let's say that you want non-refundable earnest money upon, whether it be acceptance, a few days after acceptance, upon due diligence, whatever it is, that the earnest money is non-refundable, and you automatically state, and that earnest money shall be released to the seller by whatever that time frame is. Just know that you're having this conversation with your seller, that you're in essence giving that seller option A as their only default remedy. You're in essence already predetermining that the default remedy the seller is going to choose is going to be option A. So that's one of the downsides if you're having that earnest money released to the seller. It on one side, if it's if it's being held at a title company, on one side you're avoiding the dispute of trying to get that earnest money in your possession. And so I get why it's a good thing you want to release it, but just make sure that the seller understands they're already predetermining which default remedy they're going to go for. Does that make sense?
I must not be very smart. It doesn't make sense to me.
Okay. When you are, so the three remedies that are there is go for the earnest money. That's option A. Option B, you sue for specific performance, which the earnest money would maintain the earnest money or earnest money deposits, if applicable, in the trust account and sue for specific performance. And then the third option would be if the buyer was in default, the earnest money would be returned to the buyer, and then I think this is I think I just noticed something here. Hold on a second. To buyer. Oh, okay. I mean, okay. This is what I was misreading. I was thinking that the buyer, this should say seller right here. Yeah. Return the earnest money or deposit applicable to the buyer, and then the seller, in essence, pursue any other remedies available by law. So if the seller right out of the gate says that the earnest money is non-refundable and then that shall be released to the seller, well, that means that the seller is now accepting that earnest money. So they're not returning earnest money. They're not returning earnest money to the buyer. So therefore, this ability to sue the buyer for any other liquidated damages or remedy they have by law, that is not available because the earnest money is not returned. The seller already has it. So
Okay, that makes sense.
C is not an
Thank
option,
you.
and then B, because it's not being maintained in the trust account, that issue is not being maintained either. So option A is what they've automatically accepted.
So they've already accepted damages, basically, right?
They are. They're doing it in advance, the option that they want to pursue.
So what if the earnest money's non-refundable after due diligence, but prior to financing, but the contract gets canceled before, or the buyer goes into default before that? So if they go into default before the earnest money becomes non-refundable, then all of those options are still available.
Look at it this way. Let's say that, let me phrase it a little bit different. If the buyer were to go past all of their contract deadlines, let's say accept settlement. So they go past, all of their contingencies are gone. And so technically the earnest money is no longer returnable to the buyer if they canceled, right?
Right?
The answer is yes.
Yes.
So if the buyer did not perform in that situation, then the seller would still have these same remedies except one. Remember, under section 8, if buyer's right to cancel after the financing and appraisal deadline,
Right.
if so they don't qualify for the loan, the buyer loses their job, for example. That's what this paragraph is talking about. If the buyer loses their job and now they can't get the loan anymore, so it says the proceeds of the loan are failed to be delivered by the lender, then the seller's sole remedy in that case is the earnest money. So let's just say that the buyer changed their mind. It wasn't that they failed to get the loan, but they just changed their mind and they didn't perform. Well, the buyer's still in default and the seller would still have those same default remedies. So the fact that the earnest money, where I'm going with it, the fact that the earnest money or the contract says the earnest money is non-refundable doesn't mean that the seller loses some of their rights. The fact that it's being released to the seller is when that affects the contract.
Okay, perfect. That makes sense.
Okay. But again, I understand, and I've used the language before. I understand why a seller may want to have that earnest money released to the buyer. We just need to make sure we have the conversations with our seller that they understand what they're doing by doing that. Okay. All right. We covered section 18 already. So again, that shouldn't be any issue. So hopefully that makes sense. Dealing with assignments. This is another thing that comes up all the time. Especially when you get offers from investors, an investor will write on their offer, Rob Oakey and/or assigns, right? They feel that they have by putting that language in the contract on page 1 at the very beginning, says buyer, Rob Oakey, I'll just say it's my own company, Rob Oakey LLC and/or assigns is who the buyer is. So that language makes it sound like the buyer has the right to assign the contract to anybody they choose without further any requirement of the seller. And I want to point out that is incorrect. Where this contract is not assignable unless buyer and seller both mutually agree. But it makes it very clear. If again, let's use myself as the buyer. So Rob Oakey, me as an individual wants to be the buyer, and my own company, it's Robert H. Oakey PLLC. So I go under contract as Rob Oakey, and I want to assign it to my LLC. Well, that language is protected, and I have the right to do that without the seller interfering in it. It says this contract is not assignable unless buyer and seller both agree, provided, however, the transfer of buyer's interest in the REPC to any business entity in which the buyer holds a legal interest, including but not limited to, blah, blah, blah. This is called a permissible transfer, and that shall not be treated as an assignment that requires seller's written consent. So that is not what we're talking about. I can assign it from my own person, for me individually, to a company that I have an interest or I own, and that is not assignable. But anything else, it would be. So furthermore, it says the inclusion of and/or assigns or similar language on the line identifying buyer on this first page of the REPC shall constitute seller's written consent only to a permissible transfer. That's the part that's misunderstood. They think that the only way that and/or assigns is that the seller gives written authorization for is if it's going from Rob Oakey to Rob Oakey PLLC. Any other assigns does not work. Does that make sense? Okay, I'll take the silence as the answer.
Yes, makes sense.
Yeah. So if you do accept a contract that says this and or signs, the make sure that you catch that quickly with the investor, because the other thing is when you are accepting a contract from an investor, you've also got, and they want to, and the seller's okay with having the contract assignable. Make sure you also put in your addendum that you're going to say, if the buyer does assign this contract, buyer number one assigns this contract to buyer number two, then buyer and seller shall agree to use the assignable or the assignment addendum that is provided. Put the name of the contract. Do not allow that investor to just assign it at will, because the problem that is happening is buyer number one, who goes under contract with the seller, who has the right to assign it, he assigns it to buyer number two. Well, then they have the same, buyer number two and buyer number one have the same agreement. And so now buyer number two has the right to assign it to buyer number three. And now let's say we go to 4, 5, and 6 different buyers that ultimately take this over. Well, the seller has no idea who the buyer of their own property is, because they've transferred that assignment 3, 4, 5 buyers deep. And the assignment addendum that's on the MLS does not allow that to happen. It only allows buyer number one to assign it to buyer number two, and it ends right there. And the seller also has to sign that addendum. So now the seller truly knows who's buying their property versus giving it to some other person.
So you're saying the addendum clarifies that, right?
Yes.
Okay.
So make sure you use that addendum. And it also does a very clear understanding of whose obligation. The obligation is transferring from buyer number one to buyer number two. And they make it very clear that buyer number two is now assuming the obligation. Okay, great question. Okay. And then last thing we're going to end with, if there's nothing more on that, we're going to talk about acceptance.
Yeah, Rob, that can only happen once, you said?
It can only transfer from buyer number one to buyer number two. It does not give you the ability to go from buyer number two to buyer number three.
Thank you.
Okay, acceptance. This is understanding when acceptance occurs. You must have these two things. Acceptance occurs only when all of the following have occurred. Buyer and seller have signed the offer or counteroffer to indicate acceptance, and the agent, either seller, buyer, their agent, has communicated to the other party that the offer has been signed. Okay, so we're probably all guilty of this. I think the last couple of years we probably haven't seen as much, unless you're dealing more like with a relocation transaction, but we'll see agents that should have said, hey, Greg, we verbally have accepted your offer, but my clients are not home right now to actually physically sign it, but they've decided that they want to go with your offer. So verbally, we should be under contract, and as soon as I have a signed copy, I'll get it to you. Well, a verbal acceptance is an acceptance, but again, it's because it does not comply with the statute of frauds, which says everything must be in writing. It is not binding. So whereas a full-on acceptance, if we are accepted, it's been signed and it's been communicated, that would be a binding position. So making sure that we understand, so we don't fall into that situation and say we're accepted when in reality we're not. Any question about those items? Hopefully that makes a lot more sense on the issues that we talk about that are available to you. And so that, when you're receiving offers, or you're writing the offers that pertain to this, that we have a better understanding of what it is that we're being done. So if there is nothing further, today's going to be a little bit shorter, but hopefully that helped. And feel free to reach out to myself or Jason in any questions that you may have about the transaction. Okay.
Thank you.
Thanks, everybody.
Thank you.
Bye-bye.
Thank you.